Good afternoon to everyone. Welcome to KANISHKA Educational Academy. This is Dr. Khan. I teach political science optional for UPSC and international relations also. I have been associated with many of UPSC institutes across India and also associated with KANISHKA Educational Academy. As a part of UPSC lectures, even before, since many days, KANISHKA offering many of online classes and even guidance to the UPSC aspirants. As a part of it, today I am going to teach you a current affairs polity based topic that is very important as a part of polity as well as current affairs. The topic is about 103 Constitutional Amendment Act. It came into limelight since 2019. This act, especially providing reservations to economically weaker sections of Indian society. However, after 2019, we have seen many controversies, even behalf of non-governmental organizations, even the people who are prerogatively protecting their reservations is being talking about giving reservation 10% to economically weaker sections is truly wrong. As being of an aspirant of UPSC examination, we must have in-depth analysis about acts and what is going, which is in relation to the preamble, and how we need to understand the basic structure of the Indian Constitution after Keshananda Bharati case. And how do we relate this 103 Constitutional Amendment Act to the preamble as well as basic structure doctrine? So we need to know as being a part of current affairs. So today I am going to discuss on 103 Constitutional Amendment little in depth. Even everybody knows that recently we have seen the many often petitions have been raised and the many of the peoples are talking about 10% reservation giving. Is this the right step of a government which is working on to protecting economically weaker sections of India? Aside, however, if you could take it out, base of the Constitution, is this right to providing reservations to economically weaker sections in India? Do we have any evidence so far by now that the Constitution have empowered or protected by giving a reservations to economically weaker sections, especially the asserted area that we need to talk about, economically weaker section? Do we have such evidences so far by now? All these things we'll try to understand in this lecture. Now, as a part of this, I just wanted to discuss you that so far by now, the government, means the Indian government, have provided reservations to two classes. According to the Constitution, if you see that the Constitution provided reservations to two particular areas, which is those who are socially backward, and the second category which have claimed the reservation, it was educationally backward. But nowhere since 1950, the Parliament did not provide a reservation on the grounds of economic. The criteria since 1950 to 2019, if you take it as, we did not find out any quota of reservation that have provided on the grounds of economically economically downtrodden, economically less. But we have socially backward and educationally backward. The reservations which are provided in the Constitution, 15 article, even it is article 16 in the Constitution of India, have provided reservations to the caste and the people who are literally considered as a part of socially backward as well as educationally backward. And this is the evidence which I have seen 15 class 4, 15 class 5, 16 article which talk about giving reservations to these particular areas of Indian citizenship. But now we are trying to understand now economically. But in the 2019, for the first time, the government of India, it was enacted. It would made it as an act to providing reservations to the economically weaker sections of citizens. Economically weaker section, society that it been come into the limelight, we define, these are all EWS reservations, which means economically weaker sections of the society. What is that? Economically weaker sections of the society. This has, for providing these reservations, the government of India have amended the constitution number 103 CAA, and it has provided a few of provisions that in the 2019 the government have provided 10% of quota reservations to the economically weaker sections. That is being mentioned in the 103 constitutional amendment. What are the provisions that has mentioned under the 103 constitutional amendment? We need to see that. The first one, if you could see here, is that since 2019, those a family income less than 8 lakhs of rupees, they can claim family income. They took consideration on the grounds of family income. The family income, even in the state as well as to the center, if a family income less than and up to 8 lakhs of rupees per annum, they can claim the reservations under this EWS category. The second provision, if you could see here, is that it provided 10% of quota reservations. 10% of quota of reservations to economically weaker sections of the society, you can say citizenship. And the third provision, if you could see here, is that the people who have claimed reservation in the past, such as SC, ST, BCs, are being excluded under this 103 constitutional amendment. They cannot claim the reservation under this 103 constitutional amendment. This is very, very important that you need to remember here. This is the area cannot claim the reservation under this 103 constitutional amendment. What is the fourth provision? Okay, the fourth provision, if you could see that, this reservation can apply even in public, private institutes. One can get employment in public, one can claim the educational reservation even in the sphere of public institutions. That is very, very important. According to this in 103 constitutional amendment, the EWS category can claim the reservation even public, private institutions. One can claim the benefits of employment under the public institutions, isn't it? When it comes to the point of the fifth provisions, that it empowers that the 10% of the quota of reservations and applicable those who are exactly economically weaker sections of the society. Weaker sections of the society, and this shall empower and inserted in the constitution 15 class 6, 16 class 6, article 15, article 16 have added the one more article, that is 6th class, 15 class 6, 16 class 6 shall provide it benefit to the economically weaker sections in order to claim the public employment through the public institutions. This will provide it the educationally opportunities in the state and the central private institutions as well as to the public institutions. So what you need to understand here is that strictly, very explicitly, the 103 constitutional amendment have provided reservations to 10% of quota for exclusively economically weaker sections in India. Do you understand my point? And these are all the provisions which clearly mentions under this EWS constitutional amendment. So what we need to understand so far by now, we did not find any letter in the constitution that it related to providing reservations to the economically weaker sections. But after 2019, we need to add it in special, the class in the 15A, 15 class 6 article 16 class 6, which makes us to understand even the constitutions has the evidence to providing the reservations to the economically weaker sections in India. Hope you understand that what I am trying to tell it to you, isn't it? So now, what is it in controversy which is an always is a questions to that. And also at the same time, how a state and prerogatively has a right to do the reservation. And also at the same time, which you need to understand here is that how the Parliament of India has an authority to do the reservations, and especially on the grounds of economically weaker sections. The many of peoples, even that recently the Attorney General of India announced it in uttered words that giving reservation to the citizens on the grounds of economically weaker section, it does not erode the opportunities of SC, ST, BC. Those who are existingly already at their they have been getting fruits as per the constitution. There was a controversy from various groups of SC, ST, BC that giving reservation 10% quota of economically weaker sections is being created mediocrity, as well as it's creating apprehensions to the other communities that in getting a reservations to that. But however, the Attorney General uttered a word recently that giving reservations to the people who are actually economically suffering in order to providing the opportunities in the public and private, as well as giving and reservations to the public employment, it does not erode the opportunities of SC, ST, BC. So that it makes us to understand truly that how government has a clarity for amending the 103 constitutional amendment, as well as providing the better opportunities to the economically weaker sections really. In fact, if you see this and what exactly the controversy it's been rolled out, we need to understand. However, the act has done, isn't it? The act has done. It was enacted by the Parliament of India. It is explicitly providing reservations. The most of the peoples are been claiming EWC reservations under this category. But why this becomes a mainstream issue at presently in the 2022? What are the reasons? We'll try to understand now. And here is that you need to understand exactly. The one thing is that a constitution did not have any of a letter in the reservation manner that is related to economic. We can see the socially backward reservation that you can see BCs, isn't it? BC, SC, ST, isn't it? And even for the BCs reservations, if you could see that in the 1950s, after the first BC commission, I think everybody knows that Kaka Kalekar was the first BC commission chairman who have done his research that why to give how many categories of this which are comes under the purview of this BCs can claim the reservation, and how actually there's an after 1989 the VPC government have strengthened 27% of reservations to the BCs. Already we have seen all this thing very scientifically. There were many committees have been appointed, even this Modaliyar commissions and all of that, and we can see that, isn't it? But the one thing that you need to understand here is that the controversy which is creating in the fringe of Indira Sahani case. Just I wanted to tell you the why actually this 103 constitutional amendment dragged for the controversy, why this is, and many of people are speaking that the people who know us better about a reservation, even the people who do not know anything about a reservation, they are speaking many things, they are uttering the word that violation of the basic structure. Giving reservation economically to weaker sections in India is truly considered as a violation of basic structure doctrine that you need to understand particularly. Now, here we need to understand the Indira Sahani versus Union of India case. If you could understand particularly the case, you shall easily understand that and why this 103 constitutional amendment it becomes a controversy, and why it gives a chance to the legal luminaries to formulate a 5 judges bench, which is a constitutional bench. First, I'll try to tell you that an Indira Sahani case. Then after that, I'll try to link it, the 103 constitutional amendment Is it? And the now is that, and I'm going to talk on Indira Sahani and others. Indira Sahani and others versus Union of India. Union of India case. This has came to be known to everybody 16th November 1992. The date is very important. However, when you are talking about in terms of reservation implementation of EWS, isn't it? This is an EWS. How the year is important in terms of 2019. This is also very important that you know it reshaped the reservation criteria in the Constitution of India. What was happened and what was the judgment of Supreme Court of India in the 1992 16 November Indira Sahani's case? And this have raised the pill. This has raised a pill which is public interest litigation by questioning the reservations of VP Singh government. That you need to have here a little thing that you need to understand the background of 1992 case. Okay, the first thing I just wanted to give you the clarity is that I think everybody have got to understand in this what was the provisions under 103 constitutional amendment. It is in relation to economically weaker sections of the society reservation that I have written here. You have to remember perfectly that. And then I said it that, and there is a link to the Indira Sahani versus Union of India case. This Indira Sahani versus Union of India case also linked to 1989 VP Singh's government. What has happened actually that I wanted to tell you. This also has been called it as a Mudaliar case. It is known as the Mudaliar case, isn't it? Let me tell you the brief, a political story about this VP Singh government. I think in the 1989, there was a political trauma in India. Even I think everybody knows that. That was a year before inception of liberalization policy in India. 1989, it was a year in the history of India. That was a time, it's a slightly we are getting into the political trauma. You know, one side, LK Advani ji, a great leader. I have lots of respect on him. LK Advani ji, Lal Krishna Advani ji, have been trying to attracting the votes or voters as a part of a campaign, isn't it? This campaign was truly working on the vision of India as well as to that and what actually the government is going to do it. As when they get into the public, when they address us to the people, they actually the thing which has come into the effect for a reservation matter. So far by now, if you could see here, SCs and ST acquired a reservation under the Constitution of India, but we did not see and the fully strengthened of a BC reservation which is called backward class reservation, isn't it? So then when VP Singh government have strengthened 27% of reservation to the backward classes, especially in the area of socially and as well as to this will apply to educationally backward classes, and even for one can claim the public opportunities and through this reservation one can claim the educational benefits under this reservation. You know that so far by now the SC/ST which was an acquiring and claiming the reservation, and after that then VP Singh government have strengthened the 27% of the reservations to the BCs, isn't it? And when these fear, when a kind of a psychosis gripped among the people in India, there was also a demand from a few of the communities that in relation to EWC reservation, EWS economically weaker section reservation. I think everybody knows that in the PV Narasimha Rao times. However, I'll tell you this link after this. VP Singh and the LK Advani's time, the BC reservations have strengthened and empowered. That was in the digit of 27% of the reservation have provided to people who are actually in the category of BC socially as well as to the economically backward, isn't it? So soon after that, here the thing which I have mentioned in the case that giving reservations to backward classes were right or wrong. This was questioned in the court by the Indira Sahani others versus Union of India case in the 16th November and 1992 have raised the bill to the court of India. There was an apex court, Supreme Court of India. Because why actually you need to understand that, and why all these cases actually reach us to the Supreme Court of India. What is the reason? There was an Lakshman Rekha for Judiciary of India. As well as to that, we read in the Constitution the responsibility to protecting the spirit of the Constitution. It is in the hands of Supreme Court of India.